Thanks for including me, Greg.
Oh, yeah, you're welcome. Great to have you.
Thank you.
Okay, it looks like folks are trickling, and please feel free to start whenever you're ready.
Okay. Hi, I guess we'll go ahead and get started. I'm Gregory Dresser. I'm the Director, Chief Counsel at the California Commission on Judicial Performance. I've been at the Commission since October 2017. Joining me for the presentation today is Judge Erica Yu. Judge Yu is a judge in Santa Clara Superior Court. Judge Yu was a member of the commission for 8 years as a judicial member. During that time, Judge Yu served for I think 2 years as the chair of the commission. Prior to joining the bench, Judge Yu was a litigation and trial attorney in San Jose, and she was also on the State Bar Board of Trustees. And also, just for your information, Judge Yu is tied for first as the busiest judge in the California judiciary. She's tied with the Chief Justice and Samantha Jessner, who's the presiding judge of LA Superior Court.
Thank you so much, Greg. I was on the commission for 9 years, actually. And I think part of the reason why I'm so busy now is I'm currently the president of the California Judges Association, which is about 2,500 members. And I'm only the 6th woman to lead the organization in its 95-year history. So yeah, so it's just really a pleasure to be here. It's been so great to work with Greg. In my opinion, he's done a wonderful job as the chief counsel and director of the Commission on Judicial Performance. And I understand we're here to talk about what people can do, people being lawyers and litigants in a courtroom, if they encounter bench officers who are exhibiting bias. And Greg, thank you for doing all the hard work on getting the PowerPoint ready too.
Oh, you're welcome. So just to outline it for you all, I'm going to just describe the commission a little bit, because I know that sometimes people don't know about the commission or what the commission does. We'll outline the parts of the Code of Judicial Ethics that speak to bias among judicial officers. We will also show you resources if you want to take a look into precedent or filing a complaint about a judicial officer, etc. And then we'll also discuss some commission decisions that relate to bias, as well as some decisions that relate to discipline for judges' misconduct directed at self-represented litigants. And so we hope that'll be helpful. And if you have questions, you can ask them, and we'll try to use the Q&A to ask questions, and we'll try to address them as we go. And if we miss them, we'll try to pick them up at the end, time permitting. Can you go to the next slide, please?
And can I just jump in while the slide is changing? I wanted to let everyone know that the bench officers in the courtroom that litigants and lawyers are dealing with can be judges, commissioners, assigned judges who are retired, sitting on assignment at the discretion and authority of the Chief Justice, pro tems who are attorneys, and some courts have referees or other SJOs. So some of your questions may about different status of bench officers may have us talk about different routes of remedy. So please just let us know specifically, and we're happy to give you more specific responses. Thank you, Greg.
Yes, welcome. So anyway, the commission was established by voter initiative in 1960. And so the commission is listed in the California Constitution, and all of the commission's powers are set forth in the Constitution. So if there is ever a need to have a fundamental change to the powers of the commission or to the composition of the commission, that has to be done via amendment to the California Constitution. So when the commission was established in California, it was the first judicial discipline agency in the United States. Now, all 50 states and the District of Columbia all have judicial discipline agencies of one sort or another. There is no judicial discipline agency in for federal courts, for federal judges, although they have a system by which they attempt to enforce judicial discipline, which of recent there has been the discussion and expressions of consternation about various things, as I'm sure you're well aware. Anyway, next slide, please. So this is the current composition of the commission. There are 6 public members, 3 judicial members, and 2 attorney members. At this very moment in time, we actually have 2 public member positions that are vacant, and we're awaiting people to be nominated for those positions. And just to give a little bit of explanation, the 6 public members are appointed 2 each by the Senate Rules Committee, the State Assembly Speaker, and the governor. The 3 judicial members, 2 of whom are Superior Court judges, 1 of whom is a Court of Appeal justice, they are appointed by the Supreme Court. And then the 2 attorney members are also appointed by the governor. Commission members can serve 4-year terms, and they can serve 2 4-year terms. And sometimes a member will fulfill a term of a member who has resigned, or will continue to serve until a new member is appointed in that member's place. However, no member can serve for longer than 10 years. And so after 10 years, whether there's a nominee to take the member's place or not, the member has to go off the commission. Next slide, please. So this is, and I know it's small, so it's hard to see, but this is the a screenshot of the opening page of the commission's website. The commission's website is located at cjp.ca.gov. And there are a couple things that I wanted to point out. If you look at the top right, there's a rectangle where it says filing a complaint. And if you're in the website, you can click on that, and then I think you have to click through 1 or 2 more things, but you can get to an online complaint form. So people can file complaints online and upload a certain amount of materials, not too voluminous, but can upload materials if they want us to see documents related to the complaint. The other thing I wanted to point it out is at the very bottom right, there's a link to the commission's annual report, and the annual report has statistics in it for the prior year. It has summaries of public discipline issued the prior year, and it has brief summaries so as not to identify the court or the judge or the complainant, but brief summaries of private discipline, which can be useful to see different types of misconduct for which there might be discipline. And so in terms of the annual report on Friday, I think, the annual report for 2023 will be available. If you go there now, it has the annual report for 2022. Next slide, please. So these are the levels of discipline that the commission can impose. And so the top two you see on the slide there, advisory letter and private admonishment, those are private levels of discipline. So hence the name, and they're not, publicized to the world at large. And then the other levels of discipline, public admonishment, censure, and removal, or possibly a censure and bar, those are all public levels of discipline. And so the commission can discipline a judge who has resigned or retired for conduct in which the judge engaged while they were a judge. And once judge goes off the bench, the commission can't discipline the judge for any conduct that they commit after they're a judge. And then in terms of the censure and bar, if a judge resigns or retires, the commission can no longer remove the judge because the judge isn't on the bench anymore. So the highest level of discipline for a former judge is censure and bar. So in the next several slides, we're going to look at the parts of the code of judicial ethics, also known as the canons. And so you can see the entire text of the canons in the code of judicial ethics. And when I was writing up the slides, I elided the canons just to kind of tease out the core of the canon that talks about bias, but there's additional language and subtleties that if you were really contemplating it, you might want to take a look at. Also, if there are issues with the ways that the slides are elided, that's my fault, not Judge Yu's fault.
Don't worry.
Next slide, please.
So we're now talking about the canons, so I'll be my turn to speak. I put something in the chat just to make sure that everyone knew that the Commission on Judicial Performance has jurisdiction over every judge and justice in the state and shares jurisdiction with the various superior courts over commissioners, so that if someone had a complaint about a commissioner who often hears the calendars where SRLs will appear, like, the unlawful detainer calendar or small claims or family, then the complaint should start with the superior court, the presiding judge, and then if the complainant felt that the court didn't handle it properly, they could go to the CJP to advance a complaint about a commissioner. The CJP can also discipline presiding judges or supervising judges if they fail to properly correct other judges or commissioners for their misconduct, but pro tems and assigned judges who are retired judges sitting on assignment do not, but fall under the jurisdiction of the CJP. But fortunately, Mr. Dresser was trial counsel for the state bar, so he's very familiar with the state bar rules governing attorneys and their misconduct if they exhibit bias. So for pro tems, they're attorneys sitting, basically temporarily to hear certain calendars, and they often hear traffic cases where a lot of SRLs are, and people often feel like they're not treated fairly. So if there's a complaint about a pro tem attorney, we can answer those questions through Mr. Dresser. And then retired judges are judges who are retired, and so they're no longer under the canons. They don't have to adhere to the canons unless they decide to sit on assignment. And that means they can come back as retired judges. And sometimes judges sitting on assignment are also judges who will be hearing SRL or cases that your clients will be in. So judges who sit on assignment sit at the pleasure of the Chief Justice, and they sign an agreement to be bound by the canons. So if they're committing misconduct, the complaints would go to the Chief Justice and her staff. Before I move on to the canons specifically, I wanted to see if Greg wanted to add anything to what I just said.
So in terms of attorneys acting as judges pro tem, well, when I was at the state bar, we definitely received complaints about about actions that attorneys had taken as judges pro tem, and I can think of at least one matter that was at least in investigation while I was there. So that's something where if if it's viewed that a judge pro tem engaged in some form of bias against a litigant or against an attorney, the right place to complain would be to the state bar.
Yes, and you can start that also by complaining to the presiding judge about a pro tem, because the pro tem sit as assigned by the presiding judge. So if there's something going on that a person's exhibiting bias, we definitely want to have the court know, and they won't use that person as a pro tem. Just so you know, most superior courts also have training for the pro tems, and the training should include and does include, and our county does include training on avoiding bias. So if that's happening, it's definitely something that should be addressed. And, putting ourselves in the place of SRLs, it's the worst feeling because they're not empowered. They feel like they're not really understanding, right? Because if someone's speaking legalese, as a woman of color, sometimes I hear things that seem to be biased, and I stop myself because I think, oh, I must be wrong. Am I really hearing that? Am I overreacting? So when those things happen to someone who's a self-represented litigant, I think it's really important that you're here. I'm so glad that you're doing this, and that we empower people to know where they should go to complain. But with respect to judges, the CJP is just a great place to go. The investigating lawyers are all trained. They have intake lawyers, investigating lawyers, and definitely a complainant will feel that they have an ear, that someone is listening and taking what they said seriously. So going to the canons, I know you can read these canons. I'm going to go over them, and then I'm going to go over the California Rules of Court, the standards of administration. So as you can see, this canon requires judges to perform our duties without bias or prejudice. Next slide, please. And then the next canon says that the judge shall require lawyers in the proceedings to refrain from bias, prejudice, or harassment. So, if we're in the courtroom and we can see something going on that's biased, we actually have an affirmative duty to intervene and address that situation. And also, if things are happening in a deposition and there's a transcript and the transcript's given to the judge has a duty to intervene as well, even if it's not specifically in the courtroom before the judge at that moment. Next slide, please. We're also required to ensure that our staff is free from bias. So we can't perform our administrative duties with respect to bias, our courtroom duties, but we also have to ensure our staff is free from bias. And this is difficult. It's more difficult than it ever was because of issues with respect to funding. Judges used to have their, I had my court reporter for 17 years. So we used to have our staff forever. I had my clerk for 11 years, my court reporter for 17 years, and I had my deputy for years and years. But now we're no longer able to be in a team, and we often have a different deputy in the morning and the afternoon, and we have different clerks and different court reporters. So we don't always have eyes on what's happening with respect to staff, and we can't always train them to be free from bias, prejudice, and harassment. So if something happens with staff, I think most judges would want us to have that information. So we would want the litigants or the lawyers to tell us so that we can address it with staff. Now, we as judges don't have employment responsibility over staff. There's a whole separate line of, a kind of authority. So the court exec has authority over courtroom staff, and the PJ and CJP have authority over judges and commissioners. But if we know about our staff as part of our duty to make sure that the courtroom is free of bias, we have a responsibility to follow up with staff, and if necessary, report them up their chain of command. And yes, Wynn Nielsen, our duties to ensure that staff not be biased includes the research attorneys. So if there's a person interacting with a research attorney or probate attorneys, litigants often interact with attorneys in probate or the probate examiners. If there's a sense that there's bias, there's definitely a process through which that complaint should be made, either with the judge whose case it is, the presiding judge, the supervising judge, or the court exec. Next slide, please. So the staff, as I was mentioning, shall require the staff and the court personnel under our direction and control refrain from bias, prejudice, or harassment. Next slide, please. And we should conduct all our extrajudicial activities so that they don't cast doubt on our ability to be impartial. So, you know, judges are encouraged to be in the community, to attend different events, and we can't say anything that would make us appear to be biased or partial. And sometimes there's a challenge if a judge, you know, feels like, oh, this is a casual setting. I'm at the, you know, Bay Area Legal Aid's dinner or Asia Law Alliance dinner, and I just had a glass of wine and I said something. We're not supposed to do that. We're always supposed to adhere to the canons of ethics. And we're told basically we're judges 24/7, and we have to maintain that ethical standard 24/7 because we have the privilege to have this job. It comes with that responsibility. I think that's the last canon slide. Next slide, please. Before we go to the web page, I want to share the standard 10.20 of the California Rules of Court. It requires courts to prevent bias, and it says we have a duty to prevent bias. You should all look at this because courts are really operating under this standard, and our court, for example, made a lot of efforts to meet with the state bar, the county bar, and different bench officers in different divisions of the court to ensure that we put this standard into practice. So we have a duty to ensure integrity and impartiality of the judicial system. And I'm sorry, I'm not looking at you. I have two monitors, so now I'm looking at my screen that has the standard on it. We're supposed to refrain from and prevent biased conduct. We're supposed to ensure fairness and make unbiased decisions. We are also to create local or regional committees on bias. And so all the courts now should have had a regional committee, and hopefully there's a legal services attorney as a representative to that committee. If not, I would encourage you to reach out to your courts, talk to the court executive or their staff, find out about those committees and join. You know, I mean, that's a way to ensure that the system stays free of bias if you have a voice at the table. And then information about the committee is supposed to be shared. We're supposed to create a complaint process and have complaint procedures so that litigants have a place to go if they feel that the court experience was biased. And so every court has something different. Our court has like an ombudsperson program. So I'd really encourage the legal services attorneys here to reach out to your jurisdictions, find out what your process is so you can arm or inform your litigants about the complaint process. So it's really, I think, a very useful rule of court. And I'd also encourage you to apply to the bench. We have had recently quite a few legal services attorneys, as you know, appointed as judges and commissioners. In our court alone, we've had several self-help attorneys become commissioners and then judges. That's another way that you can impact this process. Our court is relatively small. It's got 80 some bench officers, and our PJ once said that it's small enough where each new judge can impact the culture and the custom of a court tremendously. There's so many vacancies across the state, and this governor is really appointing people from all walks of life. Governor Newsom also started something called California Judicial Mentor Program. I'm a co-chair of this statewide program, and it requires or asks every county superior court to start a mentoring program to help attorneys learn this process, to demystify the appointment process and get people from diverse backgrounds onto the court as judges. So I'd encourage you to consider applying. Look for the C-Jump link in your county, or just reach out to me. I'll put my email address in the chat, and I can help you connect to the mentoring programs in your county. I know that Greg also has some stuff to add with respect to the committees on bias. So Greg, would you like to jump in there?
Sure. And just a few things, and I'll also mention that also. So when Erica says relatively small, she means the fourth largest court in the state.
Yeah, that's true.
And so you all may know that the judiciary is concerned with addressing all forms of bias, and there's currently a Supreme Court committee on bias in the courts. And let's see, Supreme Court Justice Jenkins, I think, chairs the committee. There are a handful of Court of Appeal justices on the committee, and also Superior Court judges, but also attorneys and members of the public. And they've had a few meetings. I spoke to them about the canons and about some decisions, just like we're speaking to you today. So that's an ongoing, that committee's work is ongoing. And I think there is a way to access information about them, but I'll have to figure out what that is and then attempt to circulate it to you all. Just a few comments on the canons. One of the things that the canons defines as bias, kind of separate from all other forms of bias, is sexual harassment. And for those of us who went to law school a really long time ago, we remember that there actually had to be a Supreme Court case that determined that sexual harassment was a form of sex discrimination under Title VII. But in the canons, it's specifically set forth as a violation. So you don't have to make an argument that sexual harassment constitutes bias based on gender, et cetera. It's explicitly forbidden in the canons. In terms of dealing with lawyers and lawyers exhibiting bias, there's a sentence in that canon that talks about there can be times when legitimate advocacy may require, arguments or evidence or questioning of witnesses, which out of context would seem like bias, but you might have a case that's a hate crime case. And so there will be the questioning of witnesses that will use language that that is offensive, but is necessary for proof in the case, and it's not gratuitous. Same for proving up a case of race discrimination or sex discrimination. The proof and the advocacy may require the use of language and terms and arguments that unless they were used for proof in a case would might otherwise be reflective of bias. And then back to the commission's website here. I just wanted to show you where you could find decisions that might be informative about the types of misconduct that judges can get disciplined for. So here is the page showing links to public discipline and decisions, and you'll see there's a link to, you can look up public discipline by judges' names, and you can also look up you can look up cases by the type of discipline that the commission imposed. Next slide, please. So here's a page about private discipline, and if you look down on, it's the third heading or subheading there, summaries of private discipline. Under that, there is a link to summaries of private discipline. And you can go in there, and we'll talk about some private discipline a little bit later in the presentation, but you can go in there and just see, again, they're lower levels of discipline, and the descriptions of the discipline are brief, but can sometimes be helpful in knowing that something or other constitutes misconduct under the canons. Next slide, please. So we have another page on the website where you can look, we call them compendiums, where you can look at it. They're kind of the either the people at whom the misconduct was directed or, a specific category of misconduct. So you'll see, for example, the penultimate link there, you can look up discipline for bias for, based on ethnicity, nationality, race, gender, and sexual orientation. And you'll also see there's a place where you can look for misconduct that was directed at self-represented litigants. Oh, and here's the thing that I meant to mention about the last canon that Judge Yu talked about. It talks about judges' conduct off the bench. And a thing that we've seen at least a couple times within the past few years is the off-bench conduct was conduct that judges engaged in on social media. And, they said various things that obviously reflected bias, or they liked posts that that also reflected bias. And as a result thereof, one would have reason to question, if I'm a part of this group, or I'm low income or whatever, you would have reason to question the judge's ability to be fair to you if the judge were adjudicating your case. Okay, next slide, please.
Can I just
So,
jump in, Greg? I did
yes.
put in the chat like the 6 routes to use to make a complaint. And this is specifically, I guess it also pertains to pro tems and assigned judges, but I can answer any questions about that. I know that I wanted to just be able to put it all out in writing for people, but I forgot to mention that if there is a complaint about an interpreter or an interpretation, there is a separate committee and complaint process that was required for all courts to set up. So there's definitely a route to complain about interpreters as well. Sorry, Greg. Thanks.
Oh, yeah, no problem. I'm glad you added that. So here are just, these are, I think all of the examples we gave here were portions of public discipline where the judge engaged, the judges engaged in some misconduct that reflected bias. And you'll see there for Judge O'Gara engaged in a lot of misconduct on social media. And that included liking various tweets where, the tweets themselves showed bias against people of Chinese descent, victims of sexual assault, other, disdain and disrespect for women. And, he did it in a way, or it also, as I was saying, it reflected bias in a way that one would question the judge's fairness if one were a part of one of the groups that the judge, endorsed the views of. So then you'll see there that at the second bullet, there, Judge Bennett, thought an African-American defendant was lying, and he told the defendant to stop shucking and jiving. Judge Bennett engaged in a lot of other misconduct, but that part of it definitely reflected bias. Next slide, please. So Commissioner Gianquinto posted a lot of memes on Facebook. I think, there were dozens of them, and many of them reflected bias of one sort of or another. And for this slide, I wrote, those 3 things, but there were other measures of bias. I mean, definitely bias against people who had low incomes, and just a lot of other behavior that you would not want, you do not want a judicial officer to engage in. And it says there that Commissioner Gianquinto got a censure, but it was actually a censure and and a bar, so that he cannot serve as a judicial officer anymore, like as a visiting judge or something like that. And then you'll see there also the second bullet, there was discipline against Judge Gary Creep, who got a severe public censure. For Judge Creep, there were so many comments and so many things that he said, it was really hard to summarize them. And with Judge Creep, he barely stayed on the bench after his discipline. I think there was a 6-4 vote to give him the severe public censure, with the 4 votes being to remove him from office, including my friend Judge Yu. Next slide.
Can I just add, while we're changing slides, I'm so proud of the commission because they do a lot in terms of public education, but the word doesn't always get out. So one of the things that the commission does is it videotapes its formal proceedings. Those videotapes are housed on the CJP website. And I often, when I'm teaching judges, invite them to go and look, but I think for the public, it would be useful to go and look as well, because it's so interesting when the judge is standing there before the full-on commission trying to explain their conduct, and then the questions, and then the argument of the lawyers representing the judge and the lawyer representing the commission. It's very interesting to see that in process. Sorry, Greg, go ahead.
No, I appreciate it. We had a hearing before the commission last week at the end of formal proceedings for a judge, and we had it over in the ceremonial courtroom at the federal courthouse in San Francisco. And as luck would have it, new judge orientation was happening last week too. So all of the new judges went over to see the hearing. Let's see. So you'll see there's Judge Van Voorhees, who was removed from office, and he engaged in also a lot of other misconduct, but made this bias comment to an attorney who appeared before him in the guise of advice. And then you'll see in the second bullet there was a matter involving a justice from the Second District Court of Appeal, and the justice engaged in sexual harassment of colleagues, of research attorneys in the court, also some attorneys he encountered at law-related functions and seminars, etc. Let's see. Next slide, please. And then this is a matter involving Commissioner Klashevsky, and there, the judge didn't discipline or reprimand or effectively control court staff who, made offensive jokes, some of which, reflected bias based on race and gender, also, made, racial jokes and engaged in sexual banter, and also himself, made comments reflecting gender bias. I see questions are popping up as I go, so I don't know if we want to pause.
I'm answering them as you speak.
Oh, okay. Oh,
Yes.
great.
Yeah,
great.
But there's one I probably want to answer verbally whenever is a good time.
Now might be a good time.
Okay. Okay, I just sent off an answer. Okay, so first of all, before I start answering some that should be answered verbally, I just confirmed with the lack administrator that what I put in the chat is not going to be recorded. So I'll just go back to one of the comments I put in the chat to share for those who watch this later. But there are different processes for making complaints, and I put them in the chat so that you can choose the route that works best for you. They're not mutually exclusive. You might try one route and then find you have to escalate it and try a different route. So first, you can actually speak with the bench officer directly, either yourself or through your supervisor or agency. But please remember that judges cannot talk about cases unless all the litigants are represented. So please avoid any ex parte communication of the case facts. Next, you could talk with the supervising or presiding judge yourself or through your agency or your supervisor. Third, you can talk with the court exec yourself through your agency or supervisor. Fourth, you can complain to that local committee that is set up pursuant to standard 10.20. I tried to put the standard in the chat, but it was too thick, so too big. So I'll put it in parts at a break. You can speak with a judge on that court whom you trust, because judges have an ethical duty to take corrective action. So for example, I do receive some complaints sometimes, and when I hear it, I make sure that I take appropriate corrective action, which may be to escalate it. But none of these processes give you any confidentiality assurances. So the thing that you can do is go directly to the CJP, and the CJP route offers the most confidentiality. And Greg or I can explain that. And I also want to let you know if there's a complaint about an interpreter, as I said, there's a specific route for those complaints. But when I speak to the public, a lot of times people are so concerned, and the cases recognize, even the United States Supreme Court recognizes that, judges wield, as they call, awesome power. And so often there's a real fear about making a complaint because there's a fear of retribution. But the commission offers the most confidentiality of all of these processes for complaints. And Greg, would you like to talk about that?
Yes. So the commission's investigations are confidential. That includes the complainants as a part of the investigation. And so the confidentiality of the complainant is, maintained throughout, the vast majority of the cases that we handle. If we charge a judge, we go to formal proceedings because the judge might, because the misconduct might warrant a higher level of discipline, and so there has to be an evidentiary hearing. If we charge a judge, we have to provide discovery to the judge, which includes everything that's material about the charges. And at that point, we would have to identify the complainant. The other thing that I tell people when they say they're afraid about making a complaint is retaliation, excuse me, retaliation against complainants or people who cooperate with the commission is a very serious violation, and we definitely will prosecute judges for doing it. The judge who had the hearing last week, some of the most serious charges against him, I think charges that we proved, were that he retaliated against court staff for cooperating with the commission. So I expect that decision to be out within the next 60 days. And so when that's out, you'll be able to, it'll be a public document and you'll be able to see that. And my prediction is that the judge will get disciplined for having retaliated against court employees.
And on the issue of confidentiality, so in the past, when I was on the commission was receiving about 1,200 complaints a year. And of those, only 1 or 2 cases would go to formal proceedings. I think last year, the commission received 1,400 complaints. It was like a lot, it was more. So,
right.
so of that, oh, sorry, go ahead.
I think we get more complaints because people can use the online tool that I pointed out.
Good. So of that number, you can tell the bulk of the cases, the complainant and witnesses were able to maintain their confidentiality. So it's really just 1 or 2 cases where they go to formal proceedings. But I have been in hearings which are not formal proceedings, but there's informal proceedings. I've been in hearings where the judge said, well, it would never be my staff who would complain about me because they love me. And we knew it was the staff who complained. So even at that point, the judge did not know, and there's confidentiality. So there are some questions we should answer online. Verbally, should we do that now, or would you like to continue with the slides? What do you think?
We can answer the questions and then we can
Okay.
finish up the slides after.
So one of them is, can you expound on the lack of decorum standard? What types of conduct has found to rise to that level?
Right. So, I mean, almost every year, the most disciplined type of misconduct is for judges engaging in problematic demeanor, and for that, sometimes, a judge just has, the worst day of their career and, says a bunch of intemperate things that the judge shouldn't say, but there will be discipline for it. Other judges will engage in problematic demeanor as a pattern, and you'll see that where a judge will express skepticism to litigants over and over again by saying things like "what the hell" and things like that. And sometimes we get complaints, and part of the complaint is tone and volume. And unless the proceeding is recorded, that can be something that's hard to prove. But sometimes we are able to prove that. And in terms of the specific things, I mean, it comes in it comes in a lot of different varieties where the judges will get engaged in ad hominem comments about a litigant or an attorney. Sometimes judges will make fun of inexperienced attorneys and say, I can't believe you passed the bar. I can't believe you're arguing this. Don't you know about this treaty? And in the right context, those types of comments are often the subject of discipline.
Yeah, a really famous case is one where the judge said, "Where'd you get that case? In the Upper Tokyo reports?" and said that to an Asian American public defender, and that judge was disciplined. Another time, a judge came out and there were two Black or African American defendants with their public defenders. The public had left, but the family was there. And the judge came out and said, "I guess the only way I can settle this case is to put on a white sheet and a pointy hat." And that judge was publicly disciplined. So that judge, in his defense, said, "Oh, I thought it was funny," but judges aren't supposed to use humor in that way. There's another question that I think we should answer verbally, but I'm not sure I really understand. So I'm going to say the question and maybe Greg can help. It says, "I may have missed this. When you have information about a judge's discipline, is this grounds for recusal? What are the uses of this information?" So I'm not sure if the person who's supposed to recuse is the litigant or the lawyer or the judge. So if Ms. Tamler could put the question in the chat again, we can come back and answer that. So far we've cleared out all the questions. If you are online and you are interested in people's questions, you can actually look at the answered column and you can read what the answers are to people's questions. Go ahead, Greg. Shall we go back to the PowerPoint?
Yeah. So before we went to the next slide, Eric, I was going to ask you to talk about misconduct directed at self-represented litigants, but I think you already did that earlier, right?
In a way, I did. One of the most famous cases is Judge Healy's case from Solano County. And I think all of you probably know it because it really caused a ripple when it came out. But Judge Healy was speaking to self-represented litigants, thinking he was motivating them by saying, well, if you talk to each other like this, you're going to have your daughter will grow up to be a hooker. And then somebody wasn't working, and the judge basically alluded to the person's weight and said, like that person hadn't missed a meal and they should get up and work. So all of those things are really just beyond the pale, inappropriate, unacceptable conduct, and that judge was disciplined. And so there's actually quite a bit that happens with self-represented litigants, and part of it is for judges, and I've been a judge for 22 years plus, and I've done a lot of training in the area of self-represented litigants. And in fact, we have these compendiums on the CJP website that kind of clump the various disciplines and various topics together. And I asked that when I was chair, that those be put online as teaching tools for the public lawyers and judges. And I asked that the commission prepare a compendium specifically on discipline cases regarding to SRLs, and there's quite a bit of it. But part of that is because for judges, those are the hardest cases. You know, it's hard because the litigants aren't always understanding, they're not always really in a good mood, so then they challenge the judge and put the judge in a certain mood. And when the litigant is not represented, but the other side is represented, it's kind of hard for judges to know how to strike the balance to be fair. So a lot of things happen in these types of cases where judges sometimes just lose it and lose control, and they say something or do something they shouldn't. And so I think it is, as I mentioned earlier at the top of the hour, really important for these self-represented litigants to know where to complain, how to take some of the power back, because for them, it's a very difficult experience. And I think a lot of you know about the public trust and confidence surveys that were done in California. And what we learned was that because litigants were interviewed as they left the courtroom, what we learned is that lawyers rate their courtroom experience on the win or the loss, but self-represented litigants rate their courtroom experience in terms of the judge's performance and whether they felt this process was fair, on whether they were heard, even when they lost. If the judge listened to them and the litigant felt heard, they felt the process was fair. So for us, it's really important to know when judges, us being judges, it's important for us to know when judges are not hitting the mark. And we do a lot of training to make sure that judges understand different, skills to take care of themselves, have control, and communicate with self-represented litigants so that those litigants leave, feeling that the process was fair.
And just to add to a couple things that Erica had to say, I mean, we do get a handful of judges every year defending themselves by saying, I was engaging in humor, it was an attempt at humor. And it's the thing is, if the humor is at the expense of someone else in the courtroom, a litigant or a lawyer, it's that usually is not going to be an exculpatory explanation for what the judge said. And then for part of the issue with Judge Healy was his explanation was, I was speaking the language of the litigants. I was speaking in a way so that they would understand, what I was saying or where I was coming from or whatever. And, the commission's view is, if something is discourteous, it's discourteous. And it isn't going to be an explanation to say, oh, I had to say these derogatory things about the litigants to make sure that they were understanding what I was saying. So anyway, I have a few more slides just to kind of these are actually summaries of private discipline where the misconduct was directed at self-represented litigants. So you see, the matter on the slide, there was a self-represented party, and the opposing party had an attorney, and so the judge excused a witness from the stand without offering the pro per litigant an opportunity to question and cross-examine the witness, which is kind of not only is it improper, but it's it really reflects a disregard for the due process rights of the person who's trying to represent herself. Next slide, please. And here are a couple more cases. Sometimes judges get exasperated with, my experience in court is judges get exasperated with lawyers too, but also with self-represented litigants, and then and they will say things to just try to get the attention or to get people to stop interrupting or you know, making rude comments or whatever. But you know, but there has to be a process for holding a person in contempt. There has to be a process for attempting sanction or imposing sanctions. And the problem when a judge threatens it to a self-represented litigant is the self-represented litigant won't know, oh, wait a minute, they won't know that they're entitled to some level of process, even if it's a direct contempt. They might just think, well, the judge any second now might just order the bailiff to take me into custody, or any second now the judge is going to impose a fine on me. Whereas, you know, when I was in a courtroom, I mean, I knew I was never threatened with contempt, but I knew I would have process if it was an option that was on the table. The same with sanctions. So it's a thing that, you know, judges have to be careful about threatening, even if there's frustration with the litigant.
Greg, there's a really good question in the Q&A for you. In the
Okay.
case that you mentioned, would the attorney for the represented party have a duty to alert the court that the unrepresented party wasn't having a chance to cross-examine?
I don't think the attorney would have an obligation to do that. I mean, I don't think it would be a violation of the rules of professional conduct to say that to the judge. I mean, I think the judge, you know, has an affirmative obligation to make sure that the self-represented litigant has an opportunity to be heard or has an opportunity to question the witness.
But as a judge, sometimes we're rushing and I forget or something. So I would really appreciate the reminder from the attorney representing the other side, because everyone has an interest in getting to the right decision that will stay as opposed to being overturned on appeal or something like that.
Well, and I mean, if it were me, I would alert the judge, because my fear would be I would prevail and then I would lose on appeal because it's such an obvious, you know, deprivation of a fundamental right.
Yeah. And then could I just take one stab at answering that recusal question? I just want to make sure that people understand that if the judge becomes aware that the litigant or lawyer in front of them complained about them, there is no legal obligation or duty for the judge to recuse. And the reason why our system is set up that way is to avoid judge shopping, because, you know, there could be a litigant who's sometimes there are vexatious litigants and they try to get, you know, DQ the judge. So if they could complain about a judge and then get rid of the judge and then complain about the next judge and get rid of the next judge, then everything would be stymied. So there's no legal obligation for the judge to recuse if they become aware of the identity of the complainant who is a litigant in front of them. Did you want to add anything on that, Greg?
I would just say it's a thing that we see relatively often, where a person will submit a complaint, and then right after submitting a complaint, they'll send it to the judge, or the next time they're in court, they'll say to the judge, I complained about you. Do you have to recuse yourself now? And the judge doesn't have an obligation to recuse based on a complaint. So I think this is the last slide, and you know, here's just some more you know, discipline for misconduct that was directed at self-represented litigants. You know, again, the judge makes a threat that a litigant is going to get charged with perjury without really a sufficient basis to make the threat. And then I'm sure you all know this, but you know, when small claims cases get called in many courts, they ask you to stipulate to have the matter heard by a judge pro tem, and the litigants don't have to stipulate to that, and in fact, you know, one might stipulate but the other might not, and they have a perfect right to have the matter heard by a judge. And I know that it's not, you know, a thing that judges like to do the most, because there are a lot of small claims cases, and you have to deal with unsophisticated parties who are not represented by attorneys. But, you know, in this matter where the judge got disciplined, the litigant refused to stipulate. The judge questioned the parties about who it was who refused to stipulate, and that of course made it seem like the judge was going to retaliate against the litigant for refusing to stipulate, which makes the stipulation seem less than voluntary, and also, you know, made disparaging comments about small claims litigation, which, you know, a lot of people like to use because it goes quicker and you don't need a lawyer, etc. So yeah,
sorry.
that's the end of the formal presentation.
Yeah, and it's 1 o'clock, and I think we've covered all the questions. But I did put in the chat on behalf of myself and Greg that thank you so much. You're such a truly wonderful audience. Webinars are so hard because we can't see you, but your questions and engagement have made this really a pleasure because I feel like we're connecting even though we're in this Ethernet and we can't see you. So thank you so much, Greg, for doing the PowerPoint and LAC and everyone who's here. And thank you for the hard work that you do every single day. Greg, I'm going to turn it to you.
All right. Well, yes, thanks everyone. Enjoyed it.
Thank you, LAC.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.